All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. This is the time set for argument in our civil number 17-100, Desert Mountain Club versus Eric Graham et al. Each side will have 20 minutes in which to argue its position. Appellant may have some of that time reserved for a rebuttal argument. Counsel, but you need to keep track of that time for yourself. We've conferenced this case. We've read the briefs. We're familiar with the facts and issues presented. Would each of you, as you begin your argument, identify yourself and the party you represent? Counsel for appellants may proceed.
My name is Darrell Williams. I apologize for my voice. Yesterday was the first day out of bed and at work since January 25. I've been very sick, so I can't help my voice.
Sorry to hear that. We'll be all right.
I represent the appellants in this case. This case involves an interpretation of the bylaws of the Desert Mountain Golf Club. And there are at least 4 iterations of these bylaws. It is the position of the appellants, and I think rightly so, that there's nothing in these bylaws that in any respect addresses the statutory right of the members of a nonprofit corporate organization to resign whenever they would like. The position on the other side is that the bylaws have a comprehensive scheme for transferring memberships that embraces a resignation, and that although a resignation does not involve any type of transfer of the membership, even if you resign, you are bound to these surrender, resale, and maybe get some money back provisions found in Article 4 of the various bylaws.
So it's your position then that under the bylaws, 75% of the members could just spontaneously resign without any obligation at all, leaving the other 25% to hold the bag? Well,
Holding the bag, I think, is hyperbolic.
Well, bearing the expenses.
Well, but having an asset worth perhaps as much as $100 million, as opposed to having that asset owned by the 2,000 or so people who are members.
Well, if a member resigns, there's nothing in the bylaws to suggest that their interest is retired, thereby increasing the concentration of value in the hands of other members, right?
Well, there's nothing in the bylaws that address that either. You're correct.
So if I'm one of the members who remains and I'm bearing a substantially increased proportion of the expenses, my value, the value of my investment hasn't gone up a penny because my proportional interest in the club hasn't increased, right?
Well, I think that's not correct. Let me take your scenario. I think you said 25%.
It's just a hypothetical.
Okay. So if I've got 100 people who own an interest in the club,
Mm-hmm.
and the club is worth, let's say, $1,000, and 25% resign, well, before the resignation, each of those members owned a 1/100th interest in that $1,000 value. Afterward, 75 own a 1/75th interest.
Where does it say that in the bylaws?
Well, it doesn't. It's just as how you look at what is the ownership and equity value.
Well, but the way I think the bylaws look at it is those memberships that have been resigned, assuming that's even possible, still exist and can be sold. So as a remaining member, I don't have any greater fractional share of ownership. I just have a greater fractional share of the burden of maintaining the property.
Well, what you're saying is that these memberships become, in essence, treasury stock that's owned by the company. I don't think that's exactly what happens, because it is the people who have an interest in the nonprofit who own the company, and if the company has not issued interest to other people, then there's not somebody else who owns it.
Well, I guess that's the problem. We're now way, and that was sort of the point of the question. We're way out on a hypothetical plank describing possible consequences of resignation that we can't answer with the bylaws, because the bylaws don't authorize resignation.
Well, of course the bylaws, if I may respectfully disagree, do authorize resignation.
How
because
is that?
Arizona statute is a part of the bylaws. It's necessarily included within the bylaws as though
Let's
it's
assume
expressly
that
set
statute
forth.
weren't there. Okay.
If the statute weren't there, I wouldn't be standing here.
Okay, so you would agree that if the statute didn't exist, the bylaws themselves don't authorize resignation.
No, you would have to dissolve this entity in some other fashion. Now, well, let me make sure I heard your question.
We wouldn't have to dissolve the
If the
entity.
statute didn't exist,
Right.
then you would not have this right because of the statute, which strikes me, by the way, as the pronouncement of a public policy of the state, that you can't be, shall we say, induced to become a member of a nonprofit and not have the right at any time you choose to leave, although I do concede that the bylaws can affect the timing of your departure within reason, but I don't think that the bylaws can in any impact override what looks to me like a public policy pronouncement by the legislature.
We'll get to that, but just to be clear, you would concede then that if the statute didn't exist, the bylaws don't contemplate a consequence-free resignation.
Well, no. I don't. Your question is loaded because it says consequence-free. There's nothing in the bylaw one way or another about a resignation. It just is not covered.
So how do you get out without, to take Judge Swan's scenario, without the statute, how would someone like your clients get out of the membership at the club then?
Well, that would require dissolution under the corporate statutes, I think.
So if the statute didn't exist, then you're saying that the only way someone could get out of their membership would be to dissolve the club?
You know, I have to confess that this is the first time I've heard someone raise this argument, and I have not spent any time thinking about this, and so...
Well, I think the reason I'm proceeding in this way is I think it's important to interpret the bylaws. And so if we leave the statute to one side and figure out what the bylaws actually say, then we can evaluate them in the context of the statute. So as I read the bylaws, they don't require corporate dissolution to get out of a membership. They actually have very specific, if burdensome, procedures for doing so.
Well, that's only if you wish to transfer your membership to someone else. It does not speak to the right to resign. Now, it raises a different issue, which I have not researched. If you've got a contract that has this lacuna in it that doesn't address what someone wants to do, whether or not the contract that doesn't address the issue means you can't quit and walk away. If you have ongoing contractual obligations to the entity, that would be a different matter.
Well, but don't your clients have ongoing contractual obligations to the entity?
I don't think so. They're month to month. They pay their dues and receive their benefits. They have the right to resign. They do.
Well, but the bylaws don't say that. The bylaws don't say that membership is a monthly obligation or a monthly privilege. The billings may be monthly, but the bylaws, I don't think, are written in those terms. They're written in terms of ownership of an asset that comes with responsibilities, aren't they?
Well, I guess your question, if I may continue the hypothetical, can be, if you own something, can you abandon your ownership? If you've abandoned your ownership, then the other parties that own that, aren't they benefited because now they have less of an interest to share with you? So I don't think it is though you are simply walking away from any obligation. And
I'm trying to think of another property concept where abandonment comes in. If that's really the root of your concept here, give me an analogy to some other property that you can simply abandon. I mean, I suppose you could leave your car by the side of the road and walk away from it, but that doesn't mean you don't own it anymore.
Well, I suppose if you take it to the junkyard and
transfer it to the junkyard owner, then yes, you've transferred the car for perhaps no consideration. You've given the property to another owner. But can you give me an example of abandonment in our law that actually sticks?
Yeah. Take any piece of personal property that's jointly owned. And your chair. You and I each own half of that chair.
Mm-hmm.
And one day I say to you, I'm not interested in your chair. You can have it. I'm walking away.
So you've given me my interest in the chair.
I've abandoned my interest in the chair. Or you can give it to whomever you wish. I don't care.
Right, but inherent in that concept is a transfer of ownership. Your interest in the chair you have given to me, and now I have 100% of the chair. So if we take chair and turn it into share, if one wants to abandon, to use your word, an interest, don't they then have to transfer ownership of that interest to the club?
No, because the club owns the entire asset, and if they simply walk away, then all the rest of the club members own it. It's not as though it's a general transfer to all of the members of the club.
If, under your theory, if you abandon ownership of your interest, what happens to that interest? Can the club resell it?
Yes.
Okay, so the club owns it. The club has title that it can then transfer for consideration.
Yes.
So what you're saying is that by abandoning the share, you have effectively transferred that interest to the club so that it becomes the owner and then can resell it. Is that right?
Well, on your hypothetical, I would...
No, on these facts. No, I'm out of hypothetical. On these facts, when your clients purport to resign, are they in effect transferring ownership of their interest to the club so that the club can resell it?
No, they're resigning from their membership in this nonprofit, and then the club can do whatever it wants with interest in the nonprofit. They're simply resigning as allowed by the statute.
Okay.
So,
Mr. Williams, you seem to, I think you would agree with me that your argument is tethered fairly tightly to ARS 103620A, that a member may resign at any time except as set forth or authorized by the Articles of Incorporation or bylaws. And that gives you the right, your clients the right to resign. That's your position, correct?
that is correct.
All right, I guess where I need help from you is where the second part of that subsection A, where it says except as set forth or authorized in the Articles of Incorporation or bylaws. The way I read the bylaws, there's 4 ways to leave or terminate your membership, and I know you're familiar with those. So I could see that maybe if your clients might have a right to resign, but that seems to be overridden by the Articles of Incorporation or bylaws of the club, which gives you your clients 4 ways to get out of that. So help me work through that problem in my mind.
Well, I think that exception there, except as set forth in or authorized by the Articles of Incorporation of bylaws. The question is, what does that exception modify? And that's the next previous antecedent rule. And what it is modifying is at any time. And so the bylaws can regulate and control when it is that you may resign, but they cannot affect how a member may resign. I mean, it just seems so inconsistent to what bylaws even are, which are not contract of substantive right, but rules that govern operations, like office hours and what you pay for this fee. And so it is certainly within the province of a bylaw to control when you can resign, but the exception language there does not apply to the second previous antecedent. And Arizona does follow the next antecedent rule in statutory interpretation. So the court has to, and if you don't make it modify that at any time language, you make that language superfluous, because it doesn't mean anything. If the bylaws can do more than regulate the time, then why wouldn't this statute say a member may resign except as set forth or authorized? And so to give any meaning at all to the phrase at any time, you must say that it is the antecedent that is modified by the exception clause that follows. So I've got a statute that is incorporated into the contract. I've got rules of statutory construction. We're not really transferring anything, not seeking a refund, which you get back if you follow Article 4 of the Articles. And my time is up and I need a drink of water.
Thank you, counsel.
Good morning, Your Honors. Chris Callahan, Fenimore Craig, on behalf of the plaintiff, Appellee Desert Mountain Club. And Judge Bean, I want to start with your question, how does a member get out of the club? And Judge Bergen's ruling, I think, is spot on in this context. She said the bylaws can only be interpreted to preclude a member from resigning and ceasing the payment of dues. So what do the bylaws provide? They provide specific ways that any member can leave the club at a time of their choosing. The first is what's called the membership resale program, and that came into effect in the 2014 bylaws. That allows any member of the club to set the price at which they're willing to transfer their membership through the club to a new member. So if I'm a member of the club and I want to get out, I simply notify the club that I want to sell my membership. I set the price at which it's to be sold, and in doing that, I have the knowledge of the prices at which memberships were issued in the prior month, so I can set it at a price low enough that I'm out now if that's my desire, or I can try to make more money and ride it out for a bit. That's my choice. All club members have that choice. So that's option number one. Option number two, if they're moving away from the Desert Mountain community,
There's no restriction on how low that amount could be?
There's not. The club has a right. If I come in at...
See how that could exert a downward pressure on the value of membership.
You bet. And the club has the discretion. If somebody comes in and says, I'm going to sell my membership for $1, the club can come in and buy that and make sure that doesn't get publicly offered to depress the prices. But I, as a member, can certainly set my price there. If I do that, I do have to pay the transfer fee to the club. That's what everybody agreed to when they came in. That's the safety valve. So that's option number one. Option number two, if I want to move away from the Desert Mountain residential community, if I sell my property, I can transfer my membership along with my property to the purchaser of that property. And again, because of 501c7 limitations, the new member has to be approved by the club, but absent extraneous circumstances, that's usually granted. Third, as a member, if I'm getting up in years, I can use a legacy transfer. I can give it to my spouse. I can give it to my adult child. I can give it to my adult grandchild. That's the legacy transfer. The next one, and nobody's clamoring to do this one, but if I pass away, there are provisions there governing the transfer of the membership. Finally, there's a member-arranged transfer. Let's just say, Judge Swan, you wanted to become a member of Desert Mountain. I want to get out, and we happen to know one another. And I say, hey, I've got a membership. I'm leaving. And you say, great. We can work out whatever deal we have. And subject to you being approved by the club for membership, you can acquire the membership through the club from me. So there are all sorts of ways for a member to get out of the club. Nobody is trapped there. The only fact is there is a financial consequence to exiting the club, and that's what all these members agreed to up front in their membership conversion agreements and in the bylaws. If they leave, if their membership is transferred, there is a $65,000 transfer fee that has to be paid to the club. So if I sell my membership to you in a member-arranged transfer, Judge Swan, for $35,000, I have to come $30,000 out of pocket to the club for that transfer fee. There is absolutely a cost to get out, but people can do it. And that gets back...
Yeah, but what of the point that those are some alternatives for sale that are offered in the bylaws, but the term resign doesn't appear there. Surely the drafters knew about the statute, and they didn't mention the statutory exception expressly when they wrote the bylaws.
Well, and that's a fair question, but I think it goes back to the question you asked earlier about, is there any other type of property that you can just abandon? I mean, it's not like a membership in a gym where I can go to 24-hour fitness, as often as I want for a 12-month period, but I have no ownership interest. This membership entails an ownership interest, and you can't just abandon it. Your example, well, you could leave your car by the side of the road, perhaps. But if somebody comes in and figures out how to get that car moving and gets into an accident, my guess is I, as the record owner of that car, am probably going to see a claim arising out of that because it is my instrumentality, because while I certainly don't use it anymore, I still have ownership. So you can't really abandon property. That's the distinction, and that's, I think, why resign wasn't used, because it's just a foreign concept.
Well, it's not that foreign. The word appears clearly in an Arizona statute.
Well, it does, and the statute deals with nonprofit corporations, and this club is, of course, a nonprofit corporation.
So what do you think the statute had in mind? Let's assume right now there was no argument about the bylaws. Let's assume the bylaws were 3 sentences long and didn't cover any transfers. What do you think the statute had in mind when it used the word resigned?
Well, I think when the statute was drafted, it was taken from the Model Nonprofit Corporations Act. And I think if you look at most nonprofits, clubs certainly do qualify as nonprofits under 501c7, but it's not what you typically think of as a nonprofit corporation. You think of the, Piper Institute and various other sort of nonprofits engaged in various activities, Hospice of the Valley, things like that, where you don't really have an ownership interest. Here, what you have is bylaws that occupy the field. It says memberships may only be transferred as provided for in the bylaws. And I think your questioning earlier was spot on. If a membership is resigned, it essentially is a transfer back to the club.
Okay, Counsel, what's the import of subsection B of the statute? The resignation of a member does not relieve the member from any obligations the member may have to the corporation as a result of obligations incurred or commitments made prior to resignation.
That would be an independent argument why I believe the club is entitled to prevail here, Judge Thompson, because even if you say, well, the club could have been more precise in drafting its bylaws and said, notwithstanding Section 103620A, nobody may resign, but you can only do these things. And it certainly could have done that. It didn't do that. It intended to occupy the field, and I think it did.
But subsection B
right.
may have some pertinence to Judge Swan's question, which asked, doesn't the statute sort of give an Arizona citizen the right to resign without consequence?
Well, yes and no. It can. But in this case, it doesn't. Because remember, these members, the Clarks and the Grahams, purported to resign in 2014. I believe the Clarks on January 1st and the Grahams sometime in, I think, May of that year. They entered into their membership conversion agreements in 2010. At that time, they agreed that they had reviewed and understood the bylaws. They agreed that their memberships were subject to the bylaws, and in the bylaws they are obligated to pay dues until such time as their memberships have been surrendered to the club and reissued by the club to a new member. And as Your Honor recognized in the earlier questions, that's essential to the financial viability of the club. So going back to 3620B, the club's position is that the commitment to pay dues until the memberships were reissued were made by these defendants, these appellants, no later than 2010. That is a commitment that predated their attempted resignation in 2013. So even if this court were to find that they had a right to resign their membership because the bylaws didn't expressly preclude it, it wouldn't negate their pre-existing commitment to continue paying dues until that membership had been reissued.
Appellants also argue that the club treated other people differently. Is there anything in the record about the circumstances of those other situations?
There is. When we filed the motion for summary judgment in the cases against the Clarks and the Grahams, they responded with a request under 56F to conduct discovery into that fact, and they took a number of depositions. They cited two examples to the trial court, and it looks to me like they didn't provide the appropriate citations in the appellate record, and our argument would be that we had waived that, but it's a fun issue, so let's get on to the merits of it. The merits are they've cited two individuals, Vicki Dillon Jones and Robert Stouffer. Now, what the 3610 statute says is like 3620, it's except as provided otherwise in the bylaws, number one. Number two, it says you cannot make distinctions in terms of voting, I don't want to misquote the statute, voting, dissolution, redemption, and transfer. So you can't make differences except as authorized by the bylaws. But here, if you look at what happened, the bylaws give the discretion for the club to treat members in default differently. You know, if hypothetically you had me as a member of the club and I'm fairly impecunious and Bill Gates is a member of the club could make a decision that if I left, suing me would be like trying to get blood from a stone, whereas they might reach a different conclusion with Bill Gates. And the bylaws give the club that discretion. With regard to Miss Dillon Jones, we entered into a settlement agreement with her where she paid an amount in excess of what she owed, and the club repurchased her membership. Section 4.12 of the bylaws gives the club absolute discretion to determine where and under what circumstances it will repurchase a membership. So to the extent Ms. Dillon Jones was treated differently, that's something that was authorized by the bylaws and therefore does not violate the statute. Mr. Stouffer was expelled from the club shortly after the club transitioned from developer control to member control. He was in arrears on his account for, I don't know what the exact period was, but for an extended period of time. And what Section 6.1 of the bylaws says is any member who is in default for more than 60 days on their dues or other financial obligations to the club may be suspended. Anyone who is in default more than 120 days may be expelled. That decision is committed to the club's discretion. Based on the circumstances prevailing at the time of Mr. Stouffer's expulsion, the club's decision was to expel him. The club certainly could have made that same decision with regard to the Clarks and the Grahams, but the bylaws give them the discretion to make a different decision. Because that's discretion expressly conferred by the bylaws, there's no differential treatment in violation of Section 103610.
Mr. Callahan, the appellants invoke the last antecedent rule in an attempt to, or have us try to invoke the last antecedent rule in an attempt to interpret 3620. Give me your take on your client's argument on the appellant's argument on the last antecedent rule.
Well, if you look at the Arizona cases that deal with the last antecedent rule, you have the Pawn First case and you have the Phoenix Control case. In Pawn First, the question was one of standing, and the statutory phrase in question conferred standing on a taxpayer, officer, or department of the municipality affected by decision of the legislative body or board. And the question was whether the taxpayer had to be someone affected or whether the affected phrase only modified the officer or department of the municipality. And the court concluded it only modified the latter part of the phrase. But you have a construction there that is different than ours. You have what Justice Scalia called the series, antecedent rule of construction. I've always wanted to work Justice Scalia, and I finally succeeded. In that, you have three things set up in parallel series: taxpayer, officer, or department. That's a different construction than what you have in this case. This says a taxpayer. A member may resign at any time except as otherwise provided. You've got a unitary phrase with a modifier that comes after it, and you've got no principled basis to break up the antecedent phrase in the way that counsel suggests. You have the same type of situation in Phoenix Control Systems. There you move from a statute to an insurance policy, and the insurance policy in question defined personal injury as, quote, any infringement or copyright or improper or unlawful use of a slogan in your advertising. And the question was, did the copyright infringement have to occur in connection with advertising? And applying the same rationale of pawn first, or actually before pawn first relied on Phoenix Control, it reached the same conclusion. The Justice Scalia, you've got a series construction, and there you've got a different issue than what you have here. That's argument number one. His argument number two, that it renders it superfluous, we would respectfully disagree. It makes it clear that if there is a right to resign, it's not subject to a temporal limitation. And the final point on that is, even if you accept that the except as modified by the bylaws modifies only the permissible timing of resignation, what the bylaws do is they do regulate the timing of it. They say a member, they have to continue paying dues. They can't get out of here until their membership has been reissued by the club. And that is a form of restriction on timing.
So to summarize, you would say the last antecedent rule applies only to lists.
Yes.
Okay.
I think, the point on the purpose of the bylaws and the provisions we're relying on exceeding the permissible scope, there is no authority in Arizona law that I am aware of to support that proposition. The desk practice manual we cited in our briefs show that 103206 imposed no limitations on the permissible subjects of bylaws. Rules such as we are seeking to enforce here have been applied by other clubs in other situations. We cited the Cayley case, which is fairly similar to this case. We cited the Leon case, which is a cooperative advertising association. It's a group of Plymouth and Chrysler dealers in the greater New York area, and one member of the organization didn't think he was getting his fair share from it, and a newly formed dealership in his vicinity who wasn't a member was getting the benefit, and he said, I'm done. I don't want any part of this. I don't want to contribute. But the rule said you can only get out by majority vote of the members. Now, obviously, the members aren't going to let somebody out when that other member who wants to get out is contributing to their bottom line by paying for their advertising. But the court upheld that restriction. These are viewed, and the Bennett case from Arizona is instructive. When you've got this kind of agreement, it's really not just an agreement between the member and the club. It's an agreement between each member and their fellow members. They're all together in this. There's no daddy warbucks behind the club, as Your Honor recognized, to make up any shortfall. The members make that up. And all the members committed to the club and to one another that they would not leave the club without finding a replacement member, without going through the reissuance process. That's what we're seeking to enforce. That's the bottom line. This case is about the defendants honoring the contractual commitments they made. That is the relief we seek. If Your Honors have any questions, I'm happy to address them, but I have nothing to add.
Thank you, counsel.
Thank you.
I have thought of a situation where you can abandon property. Happens all the time along my street. On the bulk trash days, people put chairs and refrigerators and stuff out at the edge of the street.
That's still a transfer of ownership, though, because if you put your refrigerator out in the alley, the city of Phoenix can and will take it and resell the metal used in it. So the city of Phoenix has title. I don't mean to restrict this only to Phoenix. Any of our fine municipalities have title and can transfer the property. So what you've in effect done is transferred your title to the city, and that prevents you from being convicted of littering, right?
Well,
You can't just abandon your property by littering and say, I've abandoned it. This is, you can only dispose of your property in that manner when authorized to do so, and in there is a transfer of ownership.
or taking it to the garbage recycling location and pushing it out the back of your pickup. That's an abandonment too. And it's facile to say that that's a transfer of ownership. It's an abandonment. And
Well, you actually pay for that privilege.
no, if you have a water bill, you can abandon as much as you want out there. There's nothing to pay. It would be different if every time you went out there, they say, well, in order to abandon this piece of property here, which we say is very valuable, you have to pay what is tantamount to a penalty, $65,000, even though this thing is only worth maybe $25,000 today.
Well, let's, in the short time we have left, do you want to comment on the notion that the last antecedent rule applies only to lists?
I think it does not apply only.
Have a
to-
case that shows that it doesn't?
Yes, I do. I don't have it on the tip of my tongue, but I can file you a citation to the case if you wish.
It's all right.
And so would you like me to do that?
No, I
Okay.
think that's
I just think what we're trying to do is penalize people by making them pay to get out when they're not getting any benefits. If this is a viable business, viable operation, certainly they ought to be able to make profit when someone says, I don't want to be there anymore. So let them go ahead and resell it. There's not a transfer of ownership until they do. Thank you.
Thank you, counsel. Thank you both for your arguments. We'll take the matter under advisement. We'll issue our decision in due course. Court's adjourned.